All rise, please. Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good afternoon, everybody. Thanks for coming in. We are your panel for today. I am John Englander. To my right is Justice Hodgens. To my left is Justice Smyth. If you've been here before, you know that we've read the papers carefully. There are a lot of issues. I don't know where people are going to want to go, but you should dive right in. Just the facts that you think we really need to know, because we've read everything. So you're Mr. Smarridge, is that right?
That's correct, Your Honor.
And just let me make sure for the appellees, the split is 8 and 7?
Yes, Your Honor.
Okay. You may proceed.
Thank you. Good afternoon, members of the panel. May it please the court. Roger Smarridge on behalf of the appellant, Town of Braintree Zoning Board of Appeals. Chapter 40B allows a local zoning board to deny a comprehensive permit if doing so is reasonable and consistent with local needs, a term of art under the statute that ties into issues of public health and safety, among others. One way for a municipality to establish such consistency is through the so-called General Land Area Minimum, or GLAM, statutory minimum. Indeed, when a municipality establishes that it has met the GLAM threshold of 1.5%, the presumption that denial, if the local board chooses to deny the permit on the merits, is consistent with local needs is irrebuttable, such that the applicant has no avenue to appeal denial.
How did you meet the 1.5%? You want to start with the denominator or the numerator?
Your Honor, I would be happy to start with either. I think really the pressing issue, though, is whether the GLAM guidelines even apply here because of the APA issue.
Why is that pressing?
I'm sorry, Your Honor?
Why is it pressing whether the guidelines apply? Let's start with the denominator, since you didn't choose. The denominator issue is whether Devon Woods should or should not be included in the denominator. As I understand it, if Devon Woods should have been included in the denominator, then you can't get higher than 1.46%. Do I have that one right?
If Devon Woods should have been included, no, with the town's highest numerator at the Superior Court, which was 81.859%, that would get to 1.489. And with rounding, that takes you to 1.5.
Okay, I understand the rounding point. Let's leave that to one side.
Certainly.
I think we should start with Devon Woods. So you don't have to start with the guidelines. Let's start with the statute. The statute says sites comprising 1.5% or more of the total land area zoned for residential, commercial, or industrial use. Right?
That's right, Your Honor.
This land is zoned residential. The Devon Woods land is zoned residential.
It is zoned residential, but if you go to the regulations, which we're interpreting it.
Well, let's start with the statute. Zoned residential.
It is zoned residential.
So your argument has to be that there's some other source of law that's going to allow you to convince us that land that is zoned residential should not be considered in the denominator.
When you look at the regulations, which apply that and interpret that statute and are duly promulgated, there's no challenge that the regulations are duly promulgated.
They are law. I agree.
They are law.
Okay.
Exactly, Your Honor. The two applicable exceptions.
Before you get to that, because I like where Judge Englander is going on this, because I was thinking the same thing, that before we even get to the regulation, if we look at the language of the statute, it says, it's talking about low or moderate income housing exists on sites comprising 1.5%, et cetera. To me, when I read that, it seems implicit, at least implicit, that housing cannot exist where it can't be built.
Well, that part of the language, I think, Your Honor, goes to the numerator. It's the total land area part that is the denominator, and here that is what Justice Englander is referring to. But the way that that language of the denominator in the statute has been interpreted and applied through the regulations is where is that development, that type of development, residential, commercial, industrial, not permitted, completely excluded. And that's where you look at the exclusions under the regulatory calculation method for GLAM.
Oh, but what you just did puts a gloss on the language of the statute that's not there.
But that's exactly what regulations are. The regulations are there to interpret and implement the
But then if we're
statute.
going to do it that way, then we have to look at exactly what the regulations say. We can't say, I'm reading the penumbra of the regulations to say wherever you can't build,
Right.
it's excluded. That's not what they say. Instead, they say very specific things.
Right, they use a specific word, Your Honor, zone, but they don't use the word or phrase zoning district, which they use elsewhere in the regulations. In other parts of the regulations, they are specific to say zoning district. In this exclusion, they did not say zone. They said an open space or conservation zone.
You're looking at 6.
Yes, Your Honor.
Total land area shall exclude any conservation or open space zone.
That's right, not zoning district, zone. And if you apply a plain English definition to the word zone there, which there's no reason not to, there's no definition in the regulation of the term zone.
Whoa. When you say there's no reason not to, I start to lose you.
Well,
That's why
how.
I started with the statute. The statute talks about zoned residential, commercial, or industrial.
Right, but we apply.
Do you think the word zoned in the statute isn't talking about zoning districts?
No, I don't. I'm not contending that, Your Honor.
Okay, so why would the word zone in the regulation not be read in conjunction with the statute to be talking about zoning districts?
Because I think what you're looking at is the purpose of the statute, and the purpose of the statute is to take as the denominator, where is the land that can be built upon? And that's what the denominator should be. And a conservation zone that is subject to a conservation restriction, perpetual, that can't be amended like a zoning district could be, then that is satisfying the purpose of the denominator portion of the statute. And under the typical rules of
Can
interpret.
we just stop for a second, if you don't mind? So the proposition you put forward was that anything should be excluded where you can't build. I can't remember exactly how you said it, but it was along the lines of,
That's the gist of it, Your
the
Honor.
purpose of it is that we should be excluding from the denominator any land which could not be built on.
Correct.
So this land, so if you take that to its logical conclusion, we're going to exclude all setback areas around a residential neighborhood because they can't be built on either. And in fact, for Devon Woods,
I would
I'm going to let you answer in a second, but for Devon Woods, that's essentially what this open space is, right? It was a cluster development where as a result of the zoning bylaws of the town of Braintree, that area had to be set aside as not buildable because they were allowed to do a cluster development.
It had to be set aside through a conservation restriction that was perpetual, whereas a regular zoning setback, you can get relief from that. You can build on those through variances. You can build on those through special permits.
Okay,
You can't do that in this 244 acres of Devon Woods where this conservation restriction applies.
So a conservation restriction of this type, you say, gets treatment that, and I was going to say special treatment, but I think I'll amend it because I think I know what your argument will be. It gets treatment as if it were one of these DEP excluded zones.
That's under the other provision, yes. That's under 4. So 6 is the commercial, conservation or open space zone. 4 is the DEP, Chapter 131, Section 40A. We've invoked both of those exclusions, but I think either of them do apply for that purpose, Your Honor.
There's no case that says what you say.
There is not.
There's also, as far as I can tell, no case that tells us how to, that goes the other direction either.
That is consistent with my understanding as well, Your Honor.
Question of first impression with respect to how you figure out what the denominator is.
I think it would be, yes, Your Honor. I don't think there's any case law looking at these regulations.
What else do you want to tell me about that issue?
From there,
And these folks probably have questions too.
and I'm more than happy to answer them, but I think one thing that I just want to note on the denominator is that the AJC did rely on the GLAM guidelines when assessing the denominator, and in fact, the GLAM guidelines contain a substantive provision regarding non-zoning restrictions not being a basis for exclusion that is not found in the regulations.
All right, let me go back to the question I asked you, because I think you may not have understood what I was saying.
And if that's the case, I apologize, Your
Oh,
Honor.
not at all. It's a complicated area, and one missaid word on either end, and things get confused. So I'm looking at the statute, and maybe it's just I'm looking at it in too simple-minded a fashion. But I look at this whole picture. We have just a couple of statutes. There's not much there. And actually, the language that's in dispute is only a few lines, so it's not a lot. And I'm in Section 20, okay? 40B, Section 20. Defining consistent with local needs. There's not a lot there. And yet, there's a stack of regulations that expound on this.
Yes.
And then there's these, what are they called?
The GLAM guidelines.
And further instructions in the appendix and all this for applying the guidelines, none of which is referenced at all in the statute. And so that's why I'm interested in just getting back to what the legislature told us to do. In putting aside numerator and denominator, because that's not mentioned in the statute either. There's a ratio that you can derive from the statute, but it's a simple ratio. And it's just taking the low or moderate income housing that exists, and then you basically compare that to the sites comprising you compare that to the total land area zoned for residential, commercial, or industrial use. So that's why I say, as I read that statute, what's implicit there is we're talking about land that can be built upon. So implicit is where if there's waterways, they're clearly not included. So I'm curious as to why we don't just take the total, as the statute says, the total land area zoned for residential, commercial, or industrial use, and take that number, and then also take the number of, okay, low or moderate income housing that exists, and then see what the ratio of that is. And doesn't that give us the number we're looking for?
Well, I think that's what everyone here is trying to do.
But it doesn't come out that way. It comes out to be this complicated mess with interpreting setbacks and whether something is maintained as a vegetated area and all that. And that just baffles me, because
I agree.
That's not in the statute.
I agree with that last part, that the active maintenance and all of that is baffling. There's no reason to do that. The regulatory guidance in the actual duly promulgated regulations, I think, gets you to this point quite clearly without further elaboration needed. But if such elaboration were necessary, it needed to be an amended regulation. It can't be these substantive rules promulgated through guidelines that did not go through the APA. That's exactly what the SJC just weeks ago said in town of Milton. Now, getting back to why is it not an easy calculation, Your Honor, it's because actually figuring out what the total land area zoned for residential, commercial, and industrial uses is unfortunately not quite as black and white as it seems. And here, getting back to Justice Englander's question about why the part of Devon Woods that we contend should be excluded, is that that area, although it falls within a zoning district where residential, commercial, or industrial use is, under the zoning bylaw, that portion of the land cannot be used for residential, commercial, or industrial use because it must have a conservation restriction placed upon it in order to satisfy the requirements of the cluster provisions of the bylaw.
I get that, but I guess and maybe there's no answer to this question, but at any point, did anyone just make an effort to make a simple calculation, to go to the town planner or the city planner and just say, can you give me a total acreage as to how much land we have that's zoned for residential, commercial, or industrial use? And what is that number?
I believe that did happen, Your Honor. And in fact, this was the initial stage in the process when the zoning board was first deciding whether to invoke the statutory minimum. And this is, I'll give you a record site. It's volume 8, page 541. The town's original denominator was actually 5,091, so lower than even the denominator excluding both Devon Woods and the OSC zoning, which is no longer at issue, 5,091, and the developer did not dispute that. Now, when it went up to the HAC, then it became a disputed issue, but not.
So we've got a lot of questions, so I don't think we should be too worried about the red light. At some point, we're going to cut you off,
Okay.
but we've got a lot of questions.
I know you have more questions. I do just want to, given that my red light is on, note one correction to a number in the board's brief that we caught last night. Just so it's clear on the record. On page 49 of the brief, we stated that the landscape numerator with our denominator, excluding only Devon Woods, would be 1.650. That actually should be 1.558. Now, at the end of the day, it's still above 1.5%, but I did just want to correct that typographic error in all due candor to the court. But I'm happy to answer any more questions that the panel has.
We may hear from counsel, I don't want to put words in their mouth, but they'll make an argument perhaps that independent of GLAM, the decision should be upheld. But you're saying essentially you can't look at the decision independent of GLAM, is that correct?
I didn't hear the last part.
Your argument is essentially we can't just extract the GLAM analysis from text.
No, it's a necessary predicate because if the town did satisfy the GLAM, then the HAC lacks jurisdiction over the board's ultimate decision whether to approve or deny the permit, and that is straight out of the regulations.
So, my question on the numerator is which argument about what you say is improper makes, what if there's one or two or three, which ones do you, because there's a whole lot of stuff, which ones do you want us to focus on?
The active maintenance.
Okay, but active maintenance is just, it seems to me, just saying landscaping.
Well, I disagree. That term is found nowhere in the regulations.
Active maintenance isn't, but landscaping is.
Landscaping is.
So my point is, if active maintenance is just used as the equivalent of landscaping, do you have a problem with that?
If it's used as a colloquialism for landscaping, no, but I don't think that's what the HAC did here.
Well, then what you'd have to do is point me to where it is you think that they have used active maintenance to exclude things that you wanted to include, okay?
There were a number of those.
That don't qualify as landscaping. You see what I'm trying to say? Or that would.
No, I don't follow, because they would have to be landscaped anyway. It's just a question of whether they satisfied the GLAM guidelines.
You say, look, this is part of the site, right? The language in the statute is site.
Well, it's landscaping. Landscaping that's overgrown, for example, Your Honor. Grass that hasn't been mowed in a month. It's still landscaped, just maybe hasn't been mowed in a month.
Is there evidence of that, and how many acres are we talking about?
I don't have the numbers right at my fingertips. We set forth, a number of examples in the brief. The other issue.
That's the purpose of my question. In other words, what I found difficult about the numerator, because I understood generally what your concern was, for example, that active maintenance was not, you're going to say, not in the regs. However, how much did it really matter became something that I was struggling to try to figure out because.
And I think I can give you the.
Five different.
I think I can give you the reason why, is that once it became clear that the HAC was going to apply the GLAM guidelines as binding law, notwithstanding the fact that they said that they did not have the force of law, the town's board asked the HAC to allow the town to submit new calculations going through that even finer on the landscaping and on the stormwater, and the HAC said, no, we're not going to reopen the hearing for that. So the town didn't have the opportunity to go to that even further level of granularity.
Do you disagree that a proportional approach to the numerator is proper? In other words, if you take a site that has, I'll say 10%, and then I'll say 25% of low-income housing on it, that you take the entire acreage of that site, and then you only give credit for 25% or for 10% for purposes of the numerator. Do you disagree with that?
We disagree on the townhouse that that's the way it should be done, because there's no basis in the regulations to distinguish between owned property and rental property to draw that 25% distinction.
There's no way to.
The regulations don't differentiate between owned property and rental property with respect.
Yeah, but I don't understand why that matters.
Because
if the townhouses, how many units, there are 8 of them, right?
There are 8 units, yes.
How many of those units are designated as affordable housing?
2.
So why wouldn't you use 25%?
Because, and I could be wrong, I believe it's if it's under 25%, that's when the whole doesn't get used. But if it's 25% or more, the whole does get used.
Use the whole, even though it's only 25%?
Yeah, that's what they did with the apartments. The apartments, it was the whole, because it exceeded the 25, it was at or above 25%, so they used the entirety.
The basis for doing that?
That's in the regulations. But the regulations don't make a distinction on that point between owned property and rental property, if I recall correctly.
I'm looking at the reg, and I'm not finding what you just told me, that you go from 25% to 100% if you reach 25%.
I apologize, Your Honor, I'm not seeing it. It's perhaps that might be in the GLAM guidelines rather than the regulations itself. I don't know off the top of my head. And if it is in the GLAM guidelines, I'd say that needs to get thrown out for the same reasons as the GLAM guidelines as a whole.
Doesn't that make a big difference to your numerator?
I think it does. We argue that it does. We argue that the entirety of the townhouse should be included, and that was summarily rejected by the HAC.
Okay.
So just going back to, I looked it up here where you pointed out on volume 8, page 541, Braintree originally came up with the number of 5091 for the denominator, and that was not disputed?
Correct. I believe it says it's right on that page.
Okay. So
I don't have the record page in front of me, but
Yep,
I have
so-
a note that reflects that it's there.
So what was the numerator at that point?
The numerator at that point was, it was actually up in the 90s at that point, because that was when the town was using the entire area of the SHI sites and had not reduced it down to the 84.519 that the town submitted to the HAC after the GLAM guidelines were
Okay,
imposed.
and so what was it that caused the departure from those numbers?
The GLAM guidelines.
Aha, okay.
Well, wait, the 5091, you saying was agreed to by the developer?
Prior to the matter going to the HAC, yes.
Well, then you were way over 1.5%. So you're suggesting that the developer agreed that you were over 1.5%? I don't think
They had disputed the numerator at that point, and I don't have the numerator off the top of my head.
Because the actual number isn't 5091, it's in like the 8,000s, right? What's the number that was found by this committee? The denominator?
The denominator that the HAC found was 5,498.27.
54, not 5091. So they're actually pretty close, okay.
Well, I mean, it's
Okay.
400 acre difference.
Yeah.
It's pretty
No, but
substantial.
I was thinking it was something else. All right, we are way over, but we haven't even touched on the other component of this case, which is the board's ultimate conclusion, even if they're going to apply the 40B rules, that they weren't going to find that the development satisfied them. And I'm in particular interested in the words open space, because I don't understand what happened here. Why is it that we're talking about open recreational space instead of simply open space? There's a bylaw that says you need 2,000 square feet of open space per multifamily unit. Am I misreading that?
No, you're not. You're absolutely correct that there is that
And that
bylaw.
is not, it's conceded by everyone, that is not complied with, right?
That is absolutely right. I believe the issue
For
was...
either of the two developments, for the apartment development or for the, okay. So
Correct. The apartment development was 350 square feet per unit, and the townhouse was 462.5 square feet per
So
unit.
why aren't we talking about open space? Is it because there was a waiver granted?
It's, I believe, because there was a statement in the pre-hearing brief at the HAC that tied the issue to the recreational component based on the statements, the testimony that was going to be given. But I don't think there's any question.
Why does it have to be tied to the word recreation? Why aren't we just talking?
In my perspective, Your Honor, I don't think it needs to be. I think the definition of open space that is set forth in the regulations includes, but is not limited to, recreation. I also think that the bylaws that contain a provision that open to be counted as open space, and the area in question has to be at least 300 square feet or at least 10 feet wide, implies that there is a...
In order for you to succeed in this argument, I'm sorry to move this along,
No,
but
it's
in
fine,
order
Your
for you to succeed in this argument, you have to satisfy two components. One, that a denial on this basis would be shown to be consistently applied.
That's right.
And I mean, I'm probably going to hear from your opponents, we're probably going to hear from your opponents that you haven't preserved this argument, but we'll have to think about that too. But it has to be consistently applied, and you have to have shown, and it was your burden, that this particular open space requirement outweighs the need for low-income housing in Braintree.
Yes, and I think on that last point, the board presented ample evidence. It had presented evidence that as recently as 2005, the town had been over 10% at SHI, that it was maintaining near 10% SHI even after the 2010 census when the numbers got adjusted. For example, as of September 2017, it was at 9.7%. And the board also demonstrated that the town participates in the South Shore Home Consortium, all of which satisfy its obligation to demonstrate there are alternate ways that the town is satisfying the local housing need.
You have anything more? You have anything more?
I just want to make sure I've read this correctly, because the committee said that the deputy fire chief testified on cross-examination that there is roof access by an aerial truck to the building, but that's not how I read his testimony. As I read his testimony, he said it was theoretically possible to put a roof ladder up there, but it wasn't safe to do so.
That's right. That's where the OSHA guidelines, which are referenced in our brief, came into play, along with the topography of the site, because while it was theoretically possible within the height limits, the actual access was so narrow and seeped away from the building that you could not get a actual ladder up to the roof without going on to the abutting properties.
And this goes to the question about equal treatment, because I find that language very interesting, because there's nothing equal about 40B developments, because they, as I read it, they're able to steamroll over all other local regulations. So for example, if there's a setback requirement that would apply to a regular development but not to a 40B, then we might not have an issue with fire department access. So in other words, if we're going to ignore the setback requirement and allow someone to be building right up to a property line, the fire department might have a problem with that with the 40B, but the issue might not come up at all in another development where there has to be compliance with the setback. So how can a municipality even prove or set about to proving equal treatment when it's unequal to begin with?
I see your point, and I don't necessarily disagree. What I would say is that the fire safety, what you would have to do, and what I think the town did do here, is show that the fire safety concerns about roof access, regarding operational setup, regarding access roads, which are all allowed, the AHJ is allowed to exercise additional control beyond what the fire code, the state fire code requires, that those are applied consistently and that they are not just ignored in other cases. I don't think there's any insinuation or suggestion that they were ignored in other cases by the Braintree Fire Department as presented to the HAC or anywhere in the record.
Is it the position of the town that the proposed development does not comply with the state fire codes?
Yes, Your Honor.
In which way?
In the provision of the state fire code that allows the AHJ to determine whether additional access is needed.
I'm talking about the state fire codes,
Well, that's
independent of what the deputy fire chief might want to add in the way of local. In other words, is it the position of Braintree that there is some distinct requirement of the state fire codes that's not met?
I don't believe so, Your Honor, or at least that's.
All right, we've gone way over, and thank you for that, but I'm going to hear from your brothers now. Of course, we'll give you folks additional time to the extent needed.
Thank you, Your Honors, and the board will rest on its briefs.
Good afternoon, Your Honors. Peter Freeman, Moriarty, Bielen, and Malloy, arguing for the private defendant.
Hello, Mr. Freeman.
Okay, so I was going to focus on the actual merits as opposed to the GLAM, and as to the rulemaking, brother counsel from the Attorney General's office for the state agencies will address that if you want that to be addressed. But let me answer some of the questions that were raised, which were good questions. As to Devon Woods, it's black and white. It has nothing to do with guidelines or anything. The land that can be excluded is land that is subject to a very particular DEP type of statute, Chapter 139, Section 40A, 131, Chapter 40A. And it's just black and white, and that's not the type of restriction.
But what seems to me what the regulations do say is that the word zoned doesn't mean zoned, right? There are exceptions to the word zoned.
As to the zone, I think
you understand what I'm saying, right? That land, that DEP land might well be in a residential zone, but it's still not going to be considered. So what the regulations establish is, if you will, the camel's nose under the tent in being some sort of exception from the statutory language.
Well, there are two things together. Devon Woods is in an area that's zoned
residential.
Right. So it should count.
Well, except that if it were subject to that DEP restriction, it wouldn't count.
That's right. But what I'm saying
so
is,
we
it's
can't
not
take the statutory language. Apparently, we can't take the statutory language as being the be-all and end-all, because there are exceptions that have been created by regulation that are flatly inconsistent with the plain language of the statute.
Well, I don't think they're plainly inconsistent, as I think one of one of the justices just said. It is vague. There's no question the statute is skimpy. The statute is skimpy and it's vague. But I would point out that this aspect is actually right within the regulations, so it doesn't even get to the guidelines issue, but it's right within the regulations.
Because you would say because the regulation has a specific exception for DEP conservation that excludes, by traditional view of statutory construction, something that is conservation land but that is not DEP conservation land.
Correct, Your Honor. Correct. So that was just
How is it consistent with the purpose of what we're trying to do here to include in the denominator land that can't be built on? How is it consistent with what we're trying to do here to include in the denominator land that can't be built on?
Well, again, as I think someone said earlier, the statute, I think it was Justice Hodgens, if you simplify it, it's a question of, okay, what land in the town is available to be developed? And water bodies, yes, that's the easiest, but you're not going to include that because, obviously there cannot be housing developed there. So that's completely
And you
consistent with
can't
then
develop something that's got a DEP restriction.
I'm
So
sorry?
you can't develop something that's got a DEP conservation restriction, right?
Right.
So we're going to exclude that too. We're going to exclude the water bodies. We're going to exclude the DEP, right?
Right. The part of the
But
problem
why
is the
don't we
DEP
also exclude property that is under a deed restriction?
Because the deed restrictions vary. There's a very specific, tight set of restrictions under that particular DEP statute, as opposed to conservation restrictions that allow some type of other use. So that's the difference. Plus the fact, again, the regulation was properly promulgated, and it's easy to apply. So that's really all I can say about that. I think
the DEP. Sorry, the conservation restriction at issue here for Devon Woods, that allows what kinds of uses? Those consistent with conservation, right?
correct.
Okay, and nothing else? No building?
Well, I guess you would have to throw out virtually all of the regulations, not the guidelines, which talking about regulations, and I think that the promulgation of those regulations is well within the administrative authority under all kinds of precedents, 30A, interpretation of
I don't
statutes that...
understand why I'm throwing out the regulations.
Well, because the regulation is specific, and it doesn't include other types of more general conservation restrictions. And again, the whole history of this statute, starting with the seminal case of Hanover, basically the SJC has repeatedly said, we're going to interpret it broadly and expansively to help expedite the creation of affordable housing. So that is a backdrop that I think should inform the analysis.
So, you know, what you said would be true if the only thing that was there is 4, potentially, but then you got 6. Total land area shall exclude any conservation zone if said zone completely prohibits residential, commercial, or industrial use, or any similar zone where residential, commercial, or industrial use are completely prohibited. What about that?
That just goes back to the argument that it's talking about zoning. Within those residential areas, or any area that is zoned, and it clearly just the very specific words in the regulation, it's talking about zoning districts, not restrictions. So it's not inconsistent to have a separate one on the DEP regulation.
Clearly,
I'm sorry?
You say clearly, your brother says in his brief, not so clearly, the word zone, the first definition of it in certain dictionaries is broader than just a zoning district. By the way, if you really wanted to say zoning district, you should have added the word district. So when you say clearly, how clear is it?
Well, it talks about zoning bylaw, regardless of how it's entitled in the zoning bylaw. You can't be more specific than that. And secondly...
Where does it say zoning bylaw?
I don't have it in front of me, but in the whole list of subsections 1 through 7.
It says
those
open
were-
space zone if said zone. There's nothing about a bylaw. I think I understand it. I don't know.
There are
Wait,
two
yeah, I
related
just have one
sections. and
question for
I
you.
should have printed it out, I'm sorry, but it is there in one of those sections, 1 through 7, in the regulation we're talking about.
I just have one question for you, in connection with the health and safety issue. So if the committee makes a finding that, in my view, seems to be erroneous, that the deputy chief testified you could put a ladder up on the roof, and on the basis of that, said that there's no evidence to the contrary about safety, that just doesn't seem to be correct. That wasn't his testimony. That seems to be really distorting what his testimony was. It goes beyond making a credibility finding. I mean, what should we do with that?
I'm not sure which inconsistent you're stating, but one of his 3 issues was that he felt as though couldn't gain roof access.
Couldn't safely get roof access, so he conceded on cross-examination that you could, sure, you could put a ladder up there,
Right.
but it wouldn't be safe to do so.
Understood.
But that was what his testimony was, and that was distorted by the committee, saying that he said, oh, no, you could put a ladder up there. There was no safety issue. That's not what he testified to.
Well, even if that's 100% accurate, the fact is there's also expert testimony from our side. We had a fire safety expert, and although a deputy fire chief obviously is knowledgeable about the fire safety codes and all of that, they didn't have an impartial third-party expert witness. And so a large part of the HAC finding in our position is that the things that he applied, Deputy Chief Sawtell, were based on his personal opinions, because we had abundant testimony that the fire code was complied with. And also, regardless of that, perhaps misconstruing or misstatement by HAC, if that's the case, of what he said, the fact is there isn't any code requirement to get to the roof. It's simply not the case. And you have to look at the case of Sunderland versus Sugarbush.
That common sense, I have a problem with that. If there's a fire, and let's say you have occupants of the building up on the roof looking to be rescued, I would say it doesn't matter what the fire code says. Common sense says you have to be able to rescue people.
Well, I'm not a fire expert, but, that's why they have fire sprinklers, and that's why they have systems that are meant to prevent that in the first place. You can't get to the top of skyscrapers. And again, it's uncontroverted, what our expert said, that it's not a requirement of the code. In fact, there is testimony also by Deputy Chief Sawtell himself that acknowledged that the fire code requirements themselves were met. His big thing outside the fire code was, in his role as AHJ, authority having jurisdiction, was his business about lack of access, based on the parking way, so-called, where he was concerned that there could be cars parked. But on that argument, he completely ignored, and the town's position completely ignores the other access. They never said it wasn't safe. There's access from Alves Avenue, off of Stores Avenue, right to the site, and the chief just ignored that. So the areas that he's expressed concern about are, to us, clearly the personal preference, without the basis, and the town even acknowledges their whole argument is based on saying that that the town has local concerns based on local ordinances or bylaws, and yet they can't cite any. It's just his, as he testified to, it's his personal opinion. The third area of his concern is he wants access to all 3 sides, and that's simply not in the code. And he was never able to cite any regulation or even policy within the town, which would be a local regulation or a local bylaw or rule, which is the whole basis for the 40B balancing test, and he acknowledged that it was his personal opinion. So, we think that again, with the expert testimony that we gave and what I just said, that the AGC was completely correct and well within their authority, and we haven't seen any indication that there wasn't substantial evidence to support that decision, which of course is the ultimate standard of review.
So what
On the
about,
open space, I would point out.
yeah, I was going to ask you about the open
Yeah,
space.
on the open space, essentially, what you said, Your Honor, and I hope that's not the ultimate finding and ruling by this court, but that is what the town is saying. They're simply saying, oh, the word recreational doesn't matter. But as brother acknowledged, which I appreciate, that's how they framed the issue. It was both in the decision, but that's how they framed the issue in the pre-hearing order at the Housing Appeals Committee.
So wait, so that's an argument that they've waived an argument about their open space bylaw.
It's tantamount to waiver. They framed it as recreational.
The board, well, it sounds to me like you don't want to talk about open space, or whether the bylaws for open space is complied with, because you want to do what was done throughout what I read here, including the briefs, and talk about open recreational space and say that's something different, right?
Well, that's correct, but I confess I'm puzzled as to why we shouldn't. Again, reading words at face value, there's no gray area. They were the ones who said, you don't have enough open recreational space. And we said, show us the bylaw.
Who's they?
The
Is
zoning
that
board.
what
The zoning board.
ZBA's,
The zoning board.
so if I
and
go
that-
back to the ZBA's decision, I'm going to find them only talking about open recreational space
Yes.
and not about open space. So what you're telling us, I think, then, is this is a late, so the way that their brief was written, where it said, oh, open recreational space is just a subset of open space, and let us explain to you why open space is not met here, that is a late entry, if you will, never seen before it came on appeal. It's a brand-new argument.
Well, are you saying that their argument is brand new?
That's what
Good.
what I'm hearing you say is, yeah, that argument is brand new.
No, I'm saying consistently, well, consistently the objection was recreational open space. The argument that they're now making is that it's tantamount, recreational open space is tantamount to open space. And even the cases that they cite, Your Honor,
I think we're on the same page, and I'm not sure why you're fighting me on this. I want to make sure I understand what your argument is. They argued in their brief, open space isn't met. We have a bylaw. It requires 2,000 square feet per unit. You guys have 20% of that. And therefore, you haven't met the open space requirements of the town bylaw. You're saying to me, as I understand it, that argument was never made below. That argument was made for the first time in their appellate briefs. Or am I missing something?
no, I see what you're saying. Now they're talking about open space, quote unquote.
Yeah.
I agree.
So you agree it was made for the first time in the appellate briefs?
Yes.
And I'm not going to find it. If I go back, it's not going to be what the board said, what the ZBA said. It's not going to be an argument that was addressed by the Housing Appeals Committee. Open space as opposed to open recreational space.
At the HAC, they got into the same thing.
They made the open space argument.
Yes.
Well, then why isn't that an argument that because you would say the board wasn't the reason given by the board?
No, yeah, right. I mean, the point is they've made the distinction all along. I didn't mean to say that it's a question of their waiving something. The point is, and I can point you to the cases that they cited, which go only to open space and trying to justify their conflating recreational open space with open space. They cite the regulations in 40B where one of the considerations can be open space, but if you look at the regulation that is clearly quoted, it talks about public open space, nothing to do with the development of a site by private entities. And likewise, the case happened to be related to Cape Cod, where I'm from.
When you go down this road, I get lost. I'm genuinely confused, counsel, okay? It seems to me that the board could have said, this project fails to meet our open space bylaw, which requires 2,000 square feet per unit, in which case we'd be asking the other questions, you know, are they applying that bylaw consistently? And even if they are, do the local needs for low-income housing outweigh that particular local concern? I read the briefs. They make an argument about open space now, but I went back and read what the Housing Appeals Committee talked about, and it's only about open recreational space. I mean, basically the HAC said the reason that this argument fails is because there is no local bylaw with respect to open recreational space.
Correct.
And it just seems to me like it's ships passing in the night. We get a brief here, and it's not talking about open recreational space. It's talking about open space.
I agree with that.
So what should we do with that?
I think you need to uphold what the Superior Court did, affirming the HAC, in that they haven't shown that there's a local bylaw, which is the heart of the inconsistent with local needs standard. And I do say that either way, you still have to address what you asked Brother Counsel about, which is, despite that, even if there is a valid local concern, they have to show that it outweighs the housing need. And despite what Brother Counsel said, they didn't put any of that in any of the arguments. They referred to some plan, but also he talked about years ago they were above 10%. The only time frame that matters is the time when this matter commenced, which was, forget if it was 2017 or 2018, but that's the applicable time frame. Were they above 10% or another safe harbor at the applicable times for this project? And
Okay, I think
they
we've
weren't.
got it, and you're well over at this point. All set, Paul? You all set? Thank you very much.
Thank you,
We'll
Your
hear
Honor.
from the Commonwealth. Mr.
Good
Hitt.
afternoon, Your Honors. I am here to defend the GLAM guidelines, but before I dive into that task, and I'm sure the many questions you may have, I want to address Your Honor's question about the deputy fire chief. So, and this picks up a little bit on the point that Justice Englander was just touching on. The problem with the deputy fire chief's testimony is still that there is no written local bylaw that the deputy chief was seeking to enforce for purposes of the consistent with local needs standard. So there is a case of this court, the Holliston case, Holliston Zoning Board, or Holliston versus the Housing Appeals Committee, that states that when the court is assessing the consistent with local needs standard, there needs to be a written bylaw, local bylaw that is being looked to. So
You know, I read that case, and I didn't see anything in there that said that the testimony of a deputy fire chief should be overlooked or ignored or anything of that nature.
Well, but here they're pointing to no greater local concern than what already exists under state law. So in that situation, the Housing Appeals Committee steps into the shoes of the deputy fire chief as a decision maker in terms of local needs and decides what is and isn't.
Does anyone on the committee actually visit the site?
I do not know the answer to that, Your Honor. I could submit a post-argument letter to answer that.
But it's interesting, so they step in the shoes of the local deputy chief.
I don't want to guess. I'm gonna assume that they probably did visit the site, but I would rather answer it in a letter so that I state it correctly, Your Honor. So now turning to the guidelines, the GLAM guidelines. These are properly promulgated guidelines within the authority of the.
You can probably tell from the way this argument has gone that nobody's really excited about talking about the guidelines, at least yet. Can we go back to the fire chief for a moment? There's this argument that goes something like, local concerns can only be things that go past the state requirement. And therefore, I mean, what seems, there's sort of this unspoken statement that, like, you couldn't say, you meaning the Zoning Board of Appeals of Braintree couldn't say, you don't meet the state requirements, because of course that wouldn't be a local need, that would be some other need. But surely the Zoning Board of Appeals of Braintree could have said, you don't meet the state fire code, and therefore we're not going to approve this.
Well, there, Your Honor, the Housing Appeals Committee is stepping in to make that decision in its super board capacity. So again, the issue that was presented to the Housing Appeals Committee and why, the decision is completely defensible is that there was no written local bylaw that was greater than what's required by the state fire code. So they were simply presented with the testimony of the deputy fire chief.
Nobody made an argument, you don't meet the state fire code with the way that you can't get to the roof, or that ladders, because of the setbacks, there's not enough room to get the ladder up. Nobody made an argument like that. That's what you're saying.
No, there was testimony from the deputy fire chief, but the Housing Appeals Committee was free to weigh it. They heard the witness live. They heard the testimony.
Oh, I understand, but okay, we're talking at cross purposes.
Yeah.
I'm talking about the state law. Okay,
Yes.
So in some of their presentation, it almost sounds like they're saying, look, nobody could possibly approve this because it's unsafe. And my question to your brother was, are you arguing, and I think he answered it quite honestly, are you arguing that you don't meet, I'm going to get this confused. Are you arguing that they, meaning the folks on that side of the table, the developer, don't meet the state fire code, either with access or the way that the slopes away, and he said he didn't think so. Is that your understanding as well?
Yes, it is, Your Honor.
All right, well, why don't we, I don't have anything further on that, though.
Okay, fine. So we'll move on, and our brief is short on that point. So getting to the GLAM guidelines. These are properly promulgated guidelines. When we use the word promulgate, they were properly issued by the department here to fill in the gaps that exist in the regulations, the very detailed regulations that exist that follow the statute. There's a large body of case law in the 40B context that recognizes that these guidelines in similar...
Guidelines can't add new policy requirements.
I agree, Your Honor.
Okay. So what do you say to your brother's comment that actively maintained is not anywhere in the regs and it's not anywhere in the statute? That's adding, that he would say, that's adding a policy requirement. And under the case law that just came down, that's invalid.
Well, I disagree, Your Honor. I think that the case that just came down stands for the proposition that where an agency uses guidelines to roll out its policy in the first instance, that's creating policy. And in that instance, those guidelines need to be promulgated under Chapter 30A, Section 2 and 3. They need to follow that procedure. Here, there are already regulations that refer to this issue, and these guidelines are simply filling in the gaps that exist in the statutory and regulatory regime. So when you...
Do the words actively maintained add a policy requirement that's not in the regs?
I don't think that they do, Your Honor. I think that because there's language in the regulation, I forget which of the regulations it is, that refers to this issue, and then the guidelines are simply adding a definition or clarity for the parties who are going to be trying to make this GLAM application or calculus before the Housing Appeals Committee that helps them understand what is and isn't counted within the DAA, the directly associated area.
Also not found in the regulation.
I agree, Your Honor. But again, these are the kind of fill-in-the-gap guidelines that
So your brother says, what about, an area that gets mowed once a year? Everybody knows those areas, right? They grow the grass up, and sometime in August, they come and they shut them down, right? And he says, why isn't that included in the site? And it's because someone has said, no, it's not actively maintained.
Well,
Isn't that a policy determination that's been made that's narrowing the word site?
It's not a policy determination in the sense of the AG versus Milton decision where it needs to be promulgated as a regulation. These are the kind of filling in the gap guidelines that there's an entire body of SJC decisions that have recognized that these kinds of guidelines are appropriate. And here, these guidelines are contemplated by the regulations that were adopted to enforce the statute. So the regulations themselves, 5603.
I'm not sure, the point is made by your brother that the word that precedes that regulatory reference is the word evidence. Evidence will be consistent with the guidelines. And so one could read that very, sensibly, that that's that the guideline, you'll follow the procedures for the taking of evidence on these issues in the guidelines, not that the guidelines get to make substantive rules.
But Your Honor, now I've unfortunately lost my
That's fine. It's probably happened to me 4 times today already. I apologize. So, go ahead.
Okay, so again, AG versus Milton needs to be read in the context of the other 40B cases, or actually all of the 40B cases that the SJC has issued in this context, and in just the last few years that have acknowledged the fact that the department can promulgate guidelines to enforce the
I don't understand that gaming commission case. It seems to me that you can't line the gaming commission case up against the case that just came down, and
Well, Your Honor, it's a bit of a puzzle to fit them all together, certainly. But I think that's why the court should be careful to not read the AG versus Milton decision too broadly. There, as we pointed out, obviously, it's dealing with a different statute, and there it's a simple case because the guidelines are acting as the regulations rather than as guidelines, trying to fill in gaps of a.
that's helpful. Do you have anything more?
Yeah, let me just ask you this, and then maybe there's not a good answer to it, but this is just something that I have a concern with, and that's and the Milton case, I think, touched upon this, and the Loper case from the Supreme Court this summer touched upon it. And that's why I mentioned earlier about, we have this small statute and larger regulations and then, guidelines, and everything seems to turn on the guidelines suddenly. And we're so far from the language of the statute. So the Supreme Court had mentioned about, the importance of following administrative procedures as a check upon administrators whose zeal might otherwise have carried them to excesses not contemplated in legislation creating their offices. And that language kind of resonated with me here because we have this kind of simple language in the statute that is now, it's evolved where it's affecting substantive rights of parties. That's one problem. But the other problem is, and I think a more fundamental problem when it comes to zoning is, the end result is, aren't we cutting out public participation in this process? Because zoning is so, it's obviously locally oriented. It's the opportunity of people to participate in their community and shaping their community. And if we turn it over to administrators who are drafting guidelines, who clearly they're in that line of work because they favor a certain view, that the guidelines probably aren't going to be impartial. They're not going to be down the middle. They're going to favor the administrative bent. Aren't we cutting people out of the process, and we're complicating it to the point where it's only the lawyers and the experts who are going to be arguing back and forth, and the average person in Braintree is not going to have a clue as to, what the argument is about. And yet we have this great statutory structure that invites the public to come in for the public hearing. We're going to have a public hearing. A public hearing about what? I mean, I don't, maybe there's not a good answer to any of that. Maybe you have something, I don't know.
Your Honor, there's a lot in that question, starting with Loper Bright. Obviously, Massachusetts, the state standard is different than the federal standard, and the Supreme Judicial Court has not in any way indicated that it's, even when it issued the AG versus Milton decision, did not cite Loper Bright as a basis for its decision concerning the guidelines ruling that it issued there. So that's just to answer one part of your question. In terms of the public participation in the process, no, this is not cutting off public participation in the process. The public speaks in many different ways. The public speaks at the local level. The public also speaks through its elected representatives who adopt the statute and elect the officials who put in place the agency heads who promulgate regulations and adopt these kinds of guidelines. So the public's participation happens in many different ways. Again, stepping back and looking at the large statutory purpose here with 40B is to encourage the development of affordable housing locally. Historically, it's been very clear that there's been a lot of local resistance sometimes to that statutory mandate, and this is the procedure and the process that was adopted by the legislature to try and balance those two different interests. So I would simply say that the public does have a role in this process at various points and in different ways.
Yeah, I just wanted to ask, we have read the supplemental briefs, on Milton, obviously, and the parties are in very different places on how Milton may impact this. And I know you're prepared to address this. We have read the supplemental brief, though. But is there anything you wanted to add, or what is your strongest argument on Milton?
On the AG versus Milton decision, Your Honor?
Excuse me?
I said on the AG versus Milton decision, the recent decision?
Yes, correct, yes.
Yeah,
Sorry,
yeah. So
yes.
again, and this kind of ties into Justice Englander's question. It's a bit of a puzzle trying to reconcile all of the SJC's cases, the gaming card decision with AG versus Milton and whatnot. But there's a sensible way to read them and sort them out. And again, it gets down to when brand new policy that's going to affect the public or impact the public is being adopted, it needs to be done by way of a regulation. But if it's filling in gaps of a policy that already is expressed in a statute or in duly promulgated regulations, then it's fair to use these kinds of guidelines. And when you look at all the different SJC cases in that context, they kind of fit into those particular buckets. Sometimes they're maybe not a perfect round in a round hole. There might be a little sloppiness on the edge, but they're basically there. And until I think the Supreme Judicial Court somehow puts them all together in a different way or says this means this and that means that, we have to read all of these cases contemporaneously. And if there are no further questions, we will rest on our brief.
We're all set.
Okay,
Thank you,
thank you.
folks. Appreciate the briefing and the argument on many complicated issues. We'll take it under advisement. Thank you, court officer. Thank you, timekeepers.
Court authorized, please.